Good morning, good afternoon, and good evening. Welcome to Seminar G of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is rights of refugees, asylum seekers, and other migrants. Of the total of 281 million recorded migrants, 26.4 million are registered refugees and 4.1 million are registered asylum seekers. Many of the other 250.5 million migrants are either economic, regime change, or climate change refugees. According to the UN's World Migration Report from 2024, the number of displaced individuals due to conflict, violence, disaster, and other reasons has surged to the highest levels in modern-day records. This seminar will analyze the protections in the Convention relating to the status of refugees and its 1967 protocol, as well as the non-refoulement provision in the Convention Against Torture. We will examine the militarization of borders and the outsourcing of border operations by wealthy countries to restrict immigration, as well as the human costs of these policies. We will discuss causes of the refugee crisis, including civil wars, military aggression, coercive economic measures, climate and food crises, and corporate land grabs. We will analyze the Trump administration's efforts to restrict refugee admissions into the United States and the welcoming of certain groups over others, and the impact of court rulings on deportation to third countries. We will also focus on Israel's displacement of Palestinians in the occupied Palestinian territories from 1948 to the present, and the legal right of Palestinian refugees to return to their lands. We have French, English, and Spanish translation. And if you go to the bottom of your screen and click on the interpretation box, you can choose your preferred language. Please put your questions in the Q&A box for our discussion following the program. And there will be instructions in the chat for closed captions, which are rough transcriptions of the program, if you want to activate that. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Our faculty for this seminar includes Camilo Perez Bustillo, Nicole Phillips, and Natasha Daliani. Each of them will speak for 35 to 40 minutes. They will then comment on each other's presentations, followed by Q&A with all of you. Camilo Perez Bustillo was born in New York City, a child of migrants from Colombia. He is professor in law and ethnic studies at St. Mary's College in California. Also, he is visiting professor of human rights and international law at the College of Law, National Taiwan University, and is research fellow in comparative constitutional law, UNILA, Brazil. He is also a fellow in Global Research Program on Equality at the University of Bergen, Norway, and he held the W. Haywood Burns Memorial Chair in Civil Rights Law at the City University of New York Law School from 2002 to 2003. Camilo was a juror for the International People's Tribunal on the Philippines in 2015. He is co-chair of the Task Force on the Americas of the National Lawyers Guild and a member of the International Association of Democratic Lawyers. He is co-founder of the International Tribunal of Conscience of Peoples in Movement in Mexico City and witness at the border in the US. Camilo is author or co-author of multiple books, chapters, and articles in both English and Spanish about human rights and international law. They include Human Rights, Hegemony, and Utopia in Latin America, Poverty, Forced Migration, and Resistance in Mexico and Colombia, published by Brill in 2016 and Haymarket in 2017. And he was the principal translator into English of Latin America's leading philosopher, Enrique Dussel, including most recently, The Theological Metaphors of Marx, published by Duke University Press in 2023. He is a regular contributor to Truth Out, Just Security, La Encrucijada, and Hecho in America. Camilo will discuss the right to freedom of movement, ecocide, genocide, and resistance amid neo-fascist resurgence. Nicole Phillips is a human rights legal observer in civil and criminal litigation and an adjunct professor at UC College of Law in San Francisco, California, where she teaches human rights and rule of law in Haiti. Nicole has testified as an expert witness on country conditions in Haiti in more than 40 U.S. immigration cases, and she has appeared before the Inter-American Commission on Human Rights and several United Nations human rights bodies on a variety of issues. From 2020 to 2024, she was the legal director of Haitian Bridge Alliance, a nonprofit community organization that advocates for fair and humane immigration policies for Haitian and other Black migrants. Nicole was based in Port-au-Prince, Haiti from 2010 to 2018, where she worked on high-profile human rights litigation and advocacy campaigns as a staff attorney with the Institute for Justice and Democracy in Haiti. She regularly provides legal and human rights analysis to U.S. and international media. Nicole will discuss decolonization instead of deportation, discriminatory immigration policies against Haitian refugees in the Americas, and the root causes of Haitian migration. Natasha Daliani is an Athens-based lawyer who has worked since 2003 in various fields of law, including civil, criminal, and corporate law. She provided legal aid in criminal cases as a state-appointed lawyer until she dedicated her work to the field of human rights, migration, and asylum. She is one of the founding members of the Legal Center Lesbos in Greece, where she has worked since 2016 as head of the legal team and represented people on the move in their asylum cases, in criminal and administrative court proceedings, and in strategic litigation before international bodies. In the fight against criminalization of migrants and migration in her work with Legal Center Lesbos, Natasha was recently a member of the defense team of the Pylos 9, and she is on the team of lawyers in the lawsuit by survivors of the Pylos shipwreck. She holds a degree in theater studies, and she acts, writes, and directs occasionally for the theater. Natasha's topic today is combating criminalization of migration and border violence at Europe's sea border, challenges and small victories. So we will begin with Camilo. Go ahead.
Thank you all. It's an honor to be here, especially with colleagues such as Nicole and Natasha, who are doing the difficult work on the front lines that is so crucial at this moment. My job is to try to provide a more overall perspective and conceptual framework, but I also want to speak from the place of enunciation, as we say in Spanish, el lugar de enunciación, which is Mexico City, which is Mexico, which is the epicenter of the ripple effects of what's unfolding in the US from the perspective of the new Trump administration and its policies, which exceed the borders of the US in terms of their impact. And we'll be talking about that, again, within a broader framework, but also more concretely. Mexico is the epicenter, in effect, of the kind of outsourcing and externalization that we'll be discussing in more theoretical terms as well. And Mexico also is exemplary and illustrative, emblematic, just like we could discuss in the EU context, Morocco, Libya, Egypt, Turkey, of what these policies mean in practice. This isn't anything new, but it has all been accentuated and intensified under this second version of Trump. It also concretely means militarization, as was already alluded to by Marjorie. On Mexican soil, as we speak, tens of thousands of troops have been mobilized, but these are Mexican troops mobilizing and militarizing the enforcement of what's referred to as, quote, public security, but which specifically includes cooperation with, and what we would argue is collusion and complicity with the externalization and the outsourcing of the most regressive aspects of the Trump administration's policies as to migration, the enforcement and the persecution and terror against migrants in transit on Mexican territory, including migrants of Mexican origin. So Mexico is a very concrete, important case in this framework. But let's try and zoom out and speak about this more broadly in terms of the context and move to the next slide in terms of the right to freedom of movement and its framework. We want to start with the cases of Gaza and Palestine as touchstones. We want to think of Gaza and Palestine and the implications of the cases of Gaza and Palestine as both points of departure and of arrival. We want to understand the ways, and this has been something that is very powerfully argued by a leading Palestinian legal scholar in a very recent, a really monumental contribution to this kind of thinking, Rabea Egbaria's work, his seminal article that was initially suppressed, published finally by the Columbia Law Review, where he develops the concept of Nakba as a way to fill the vacuum of conceptualization of the Palestinian question legally, epistemologically, and ethically and politically with the issue of restrictions on the right to freedom of movement at the center, where he talks about the ways in which processes of forced displacement, exile, refuge, and eventually issues of forced migration, the right of return, all of these are central to and characteristic of the Palestinian question, understood from the perspective of the Palestinian people, their diaspora, and the ongoing processes of ethnic cleansing and genocide, and the reasons why a new conceptual framework which he defines and others have as Nakba, the catastrophe, which is essentially the conceptual equivalent to the Shoah or the Holocaust, but from the perspective of the Palestinian people. So this centers for us, for the purposes of our discussion today, the direct connection between the Palestinian question and issues of freedom of movement. And this is very strongly founded as a matter of international law and is made explicit and explored in depth in the historic advisory opinion of the International Court of Justice itself in 2004, in July 2004, regarding the legality of the Israeli wall on Palestinian occupied territory, which in turn laid the foundation for everything else that has emerged from the ICJ, and more recently, in a much more incipient form, from the ICC, as to crimes against humanity and genocide with regard to Palestine. So again, it's understanding the relevance and the connection between the Palestinian question and issues of freedom of movement. This is not the usual way in which we look at the question of Gaza and Palestine, but it's very, very important as a point of departure for our understanding today, because it's precisely what then deploys conceptually the issues related to genocide and ecocide, which I will be focusing on. All of this, of course, has taken on greater importance recently as we speak, as the politically induced and militarily induced starvation and famine unfold in Gaza and the other related policies in the occupied territories, promoted by the Israeli government with US support and collusion and participation, as they've moved explicitly towards promoting massed forced expulsion, echoing the original Nakba of 1948. So again, none of this is academic, none of this is theoretical. Next slide, please. What we're then speaking of is the equally central importance of issues of racism and xenophobia. Because again, the other guiding thread to our discussion, when we understand the way in which we approach issues related to genocide, is from the perspective of the centrality of issues related to racism and xenophobia, and how essential those are to the classic cases of fascism in its classic expressions in the 1920s and the 1930s, in Mussolini's Italy, in the invasion of Ethiopia, in the origins of Nazism in the German case, in the Franco regime in Spain, and through its colonial regimes in Northern Africa, and particularly in Morocco, etc., but also the ways in which racism and xenophobia continue to be central today to the neo-fascist phenomena that have been emerging through Trump, through Le Pen in France, through Meloni in Italy, through Nigel Farage and Brexit and the Reform Party in the UK, through AfD in Germany, through Vox in Spain, et cetera, through the ideological role of great replacement theory originally developed by Renaud Camus in France, through white Christian nationalism as the guiding ideological thread, and the expressions of all of this in neo-fascist populist authoritarianism, with migrant communities and families as the targets. So again, this takes very concrete form, and all of this builds on Tendai Achiume's foundational insights and that of contemporary decolonial praxis and scholarship, which understand modes of contemporary migration as processes of decolonization, as we'll be hearing from Nicole, in resistance to globalized structures of domination, which are, and here we come back to again, the other guiding threads, which are inherently and actively often both genocidal and ecocidal. and the ways in which genocide and ecocide are threaded together. The next slide, please. So what we're speaking about here, another key guiding thread, is the imperative of decolonization of human rights, international law, and international system, and of the international system itself. And that's the only way we can take the issue of the right to freedom of movement seriously, is if we make operative this imperative of decolonization. Concretely, in the spirit of the life and work of Monique and Roland Weil, as is posted in the preamble, the mission statement of the People's Academy, no human rights without the rights of people, no individual rights without collective rights, no political and civil rights without economic, social, and cultural rights. In this sense, a universalist vision of human rights, a redefinition of what is meant by universalism from the perspective of this imperative of decolonization. This is how that redefinition, radical redefinition of universalism is understood from the perspective of the Latin American School of Human Rights, which I am trying to share with you as a perspective today. The Latin American School of both human rights and international law, whose origins go back to the 1500s and to its most influential currents today, as reflected in some of its leading exponents, such as Antonio Augusto Cansado Trinidad, who served uniquely both on the ICJ and presided the Inter-American Court of Human Rights, the only figure to share both roles and to play a leading role in both courts, bringing these perspectives to bear. And those who've laid the philosophical and theoretical foundations for this perspective, such as the work of Enrique Dussel that's already been referred to, Ramon Grossfogel, and others. So when I refer to the Latin American School, I'm referring again also to its contemporary exponents, both through jurists and their jurisprudence, their case law, their theoretical work, such as Cansado Trinidad, but also Dussel, Grossfogel, etc. So we're speaking again about the imperative need to decolonize human rights, to decolonize international law, to decolonize our understanding of law itself, how these are taught and practiced. And of course, this is what the People's Academy is all about. And all of this as part of the even broader task of decolonizing the international system itself, and more than ever today, in the wake of the crisis that Gaza symbolizes for the system as a whole. And this is what Dussel refers to in an extraordinary posthumous book just published in Spanish, what he refers to as the task of epistemological decolonization, which I'm seeking to bring to bear today on our discipline of law.
Camilo, please slow down just a bit for the interpreters. Thank you.
Sure, sorry, thank you. The next slide, please. So again, the centrality of genocide and ecocide, this is precisely one of the great contributions of the Latin American School. When I speak about this perspective of the system of 500 years, we're referring to the need to transcend modernity itself. This is what the work of Wallerstein in the context of world system theory, what Chomsky, what Dussel all converge around. This is grounded in the recognition of the foundational role of the European conquest of the Americas and its aftermaths and its continuing legacies, including the African slave trade and slavery, and continuing issues of reparations, and how they shape how we should approach, for example, questions of Haitian migration today, as we'll be hearing, for example, from Nicole. Or in the context of Europe, African migration today in the wake of decolonization in Africa with respect to Europe. And then when we speak about the 80th anniversary of this so-called rules-based international order that is so central to the liberal understanding of the international system, the UN, Bretton Woods, the Nuremberg trials, NATO. This week, as we observe the 80th anniversary, not just of Hiroshima and Nagasaki this week, but also of the signing of the Nuremberg Charter that same week in London. All of that at the same time. And the dual origins of that liberal, of that blood-soaked liberal order, its dual origins in mass crimes that included both the Shoah, the Holocaust, and the Second World War itself, and Hiroshima and Nagasaki. And let's take into account in our thinking about this, the ICJ's discussion and debate in its 1997 advisory opinion about the inherently genocidal, and today we would say ecocidal, character and potential of nuclear weapons as we listen to the surviving victims of Hiroshima and Nagasaki this week, who just won the Nobel Peace Prize last year. Let's then understand the transformation of the international system by national liberation struggles, decolonization, the Chinese and Cuban revolutions, Algeria, Vietnam, South Africa, etc. All of this as background to take the right to freedom of movement seriously against this background, against the critique of the dominant liberal framing of this rules-based system, and understanding what we need to transform this system, and to understand the significance of the recent decisions in terms of the potential transformations of this system into something else, much closer to our aspirations of justice, through the decisions of the ICJ recently and of the Inter-American Court of Human Rights that affirm the right to a healthy environment in the context of what is referred to euphemistically as climate change, as a basic, foundational, transversal human rights, and incipiently the recognition of nature itself as a justiciable subject of rights, which has already been recognized through the constitutions and laws of states in Latin America at a very advanced stage, such as Ecuador and Bolivia, and in certain other jurisdictions around the world. And in that context, recognizing the connection between this recognition of the right to a healthy environment and the right to freedom of movement, and the right of those whose freedom of movement is impacted by environmental damage, by climate change, to varying forms of reparation and compensation, and not to be returned to conditions of precarity, in other words, to non-refoulement under such conditions. So all of that is contained in the decisions of the ICJ and of the Inter-American Court. If we can move to the next slide. The intertwining of these rights is the key thing. This also takes us to another framework that I think is important for us to have in mind as we talk about making the right to freedom of movement meaningful, is the concept of migrant genocide, which we've developed within the framework of the collective work of the International Tribunal of Conscience of Peoples and Movement. This is especially relevant in August. I already alluded to the relevance this week of the anniversaries of Hiroshima and Nagasaki, of the signing of the Nuremberg Charter. Also in August, August 3rd, was the anniversary, the 6th anniversary of the El Paso massacre in 2019, specifically targeting people of Mexican origin understood as migrants during the first Trump administration in the single largest, the single most significant mass crime against people of Mexican origin, against Latinos in US history in the last 100 years. Not generally observed as such, not generally understood as such, much less its broader genocidal implications. Not simply a mass shooting, but much more something that should be understood in the same framework as similar acts of mass racial terror, such as the Christchurch similar mass crime in New Zealand and the mass terror in Utoya, Norway, both of which were Islamophobic and targeting migrants specifically of Islamic or Muslim origin, but also mass shootings of a more specifically racist character, targeting migrants or targeting persons of African descent in Buffalo and Charleston. But also, August is the month, August 22nd, 23rd will be the anniversary of the San Fernando massacre in Mexico, which targeted migrants from origins in 6 different countries, from El Salvador, from Honduras, from Guatemala, from Ecuador, from Brazil, and 1 migrant from India, 72 victims, August 22nd, 23rd, 2010 on Mexican territory, which is the massacre that gave birth to the International Tribunal of Conscience. It was founded in the wake of that massacre, and we'll be observing that commemoration in the next couple of weeks. And that massacre became emblematic of Mexico's role, which I alluded to at the beginning of this presentation, as the epicenter of this unfolding process of outsourcing and externalization. What we see, in essence, when we allude to the framework of migrant genocide is this combination of tens of thousands of predictable and thus preventable migrant deaths at borders or en route throughout the world, at the peripheries of the US and the EU, but also in East Asia, in the deserts, seas, and mountains around the world, as the necessary cost of the current policies that are unfolding in the US, in the EU, and elsewhere. This has been recorded by the International Organization for Migration in 2025, and its most recent report, with 2024 as the deadliest year on record. Over 8,900 deaths, more every year for each of the last 5 years, 76,000 since 2014. And for example, in the context of Mexico, we do not even have a count of the number of missing migrants. This is only the number of estimated deaths. And we can hear more about this, we will, I'm sure, in one form or another, from Nicole and from Natasha. The way in which the Mediterranean and the Aegean have been transformed, in effect, into mass graves, mass cemeteries for migrants. All of this we've sought to document and to denounce from the framework, from the perspective of the International Tribunal of Conscience of Peoples and Movement and of the Permanent Peoples Tribunal. And all of this builds, for example, on the theoretical work of Mbembe in necropolitics and elsewhere. So again, this is the framework that we're alluding to in terms of migrant genocide. Let's move on to the next slide. Here we're building on the theoretical insights, the permanent state of emergency that's alluded to by Walter Benjamin, the right to have rights that's alluded to by Hannah Arendt. Again, anybody who knows anything about their perspectives and their experience will understand why their work is so important from this perspective. This leads us to the ways in which we've sought to develop the concept of peoples in movement, which is the, let's say, the suffix of the International Tribunal of Conscience. The idea of situating the right to freedom of movement found in Articles 13, 14, and 15 of the Universal Declaration of Human Rights and Articles 12 and 13 of the International Covenant on Civil and Political Rights within the overall framework of human rights and international law, developing an integral framework for what are the categories that are otherwise normally approached in a much more dispersed and fragmented way as migrants, refugees, displaced persons. That's the concept of peoples in movement. In other words, collective subjects of transnational rights with the convergence between migrants and indigenous peoples as the two sectors that are most excluded from the hegemonic core of international human rights in its dominant framework. And from a Latin American context, it's clear that increasing numbers of migrants are of indigenous origin and of African descent. So in both cases, what we're talking about is in practice and in theory, linking migrant demands to demands for self-determination and autonomy in terms of this framework of collective rights. So this means understanding the convergent demand of migrant movements and their allies throughout the world for the universal recognition of freedom of movement, or the right to human mobility, as it's often referred to, el derecho a la movilidad humana, as a justiciable right, grounded, as I mentioned, in the Universal Declaration of Human Rights, in the International Covenant on Civil and Political Rights. And again, this is developed in detail in the 2004 advisory opinion on the Israeli wall, in the judgments of the ICJ and advisory opinions, and respectively of the Inter-American Court of Human Rights. These are found, these rights to freedom of movement are found in the Ecuadorian Constitution of 2008, in Articles 40 and 42, in a local law in Mexico City that we fought for on human mobility, and more theoretically, going back to the 1500s, in the work of Francisco de Victoria on the concept of jus migrandi, more recently the work of Luigi Ferrajoli, of Giorgio Agamben. They're found more, let's say, in terms of their ethical and philosophical dimensions in the conceptualization of the rights and duties of hospitality and sanctuary, in the praxis and demands of global migrant movements and their allies, in the work of Jacques Derrida of Catholic social teaching. And politically, what we're speaking about is all of this within the broader abolitionist horizon. In Spanish, we say, todos los derechos para todas y todos sin fronteras. All rights for all without borders. The next slide, please. What this builds on in terms of theoretical insights is a fundamental recognition of, under the hegemonic system of human rights within the liberal framing, the inequality of rights and rights holders, or what we've described 25 years ago as the poverty of rights. The differentiation between hegemonic and counter-hegemonic interpretations and approaches to human rights and international law. Of course, this has been developed in third world approaches to international law and affiliated approaches in Latin the Latin American school that I alluded to in decolonial critiques. Ultimately, what we're talking about, and of course, this is deeply grounded in the work of Richard Falk and others, the need to shift from a global system centered around the rights of nation states to one centered around the rights of peoples. So that's why, again, the importance of recognizing the subjects of the right to freedom of movement as transnational subjects of collective rights. The roots of this of course, are in decolonization, in the non-aligned movement, in the new international economic order, in the right to development, in what's happening now to a limited and incipient degree within BRICS and beyond, the shift from unipolarity to multipolarity, the shift from national sovereignty to people's sovereignty, etc. The key recognition here, of course, from Orwell and others, not all rights or right holders are equal, the poverty of rights, especially where the full recognition of their rights, for example, the rights of those described as migrants or indigenous peoples, A, challenge limits imposed by colonially imposed national borders and notions of national sovereignty, and or B, of course, capitalist imperatives. This is what Richard Falk referred to respectively as the barriers of state logic in the first instance and, quote, market logic in the second instance in his path-breaking book 25 years ago, Human Rights Horizons. And so migrants and indigenous peoples are crucial case studies within that framework. Next slide. So all of this we place within the broader framework of the global retreat from human rights and international law, the current crisis in the rules-based order, ecocide as exploding the system in all of its assumptions and euphemisms. That's what's clear in the recent ICJ decision and the recent Inter-American Court of Human Rights decision. All of the ways in which this leads us into a deeper discussion about the convergent and overlapping phenomena and crimes that frame the so-called root causes of forced migration, and how these lead us to understand, this is something that we've affirmed from the perspective of the collective work of the International Tribunal of Conscience, that there are three forms of violence that we have to understand. The hegemonic approach to human rights tends to stress only one form of violence as relevant for an understanding of rights and of remedies: state violence, the violence that comes with a uniform, with a badge, with a weapon that's officially sanctioned, state violence. We affirm that there has to be a recognition of the other two crucial forms of violence, which are respectively structural violence and systemic violence. Structural violence, precisely the so-called root causes, structural violence such as poverty, inequality, discrimination, racism, patriarchy, etc., and systemic violence, which is the violence inherent in global neoliberal capitalism itself. So state, structural, and systemic violence. The right to freedom of movement cannot be meaningfully understood unless all three forms of violence are addressed. The next slide. So what we're seeing in practice, and I'll be closing more or less with this, is the globalization of a US migration policy paradigm that was imposed post 9/11. Many do not realize this, but the Department of Homeland Security, Immigration and Customs Enforcement, ICE, all of the current apparatus and mechanisms of terror on the ground in the US, in the streets of LA, at the border, in immigration courts today, and their outsourcing, all of these were innovations post 9/11. They began to be set into place and practice in reforms prior to 9/11, but they did not take a formal structure until post 9/11. There are 6 key elements to this paradigm, and this is what we see unfolding as we speak. The militarization of borders, securitization, the subordination to the supposed imperatives of national security, criminalization of migrants, border communities, and of both communities and countries of origin and their families, externalization and regionalization of these policies, what's referred to colloquially as outsourcing, which means the transfer of enforcement, costs, and practices of deterrence to Mexico, and of course, in the context of the EU, the other countries of transit and origin, regionally and globally. 5, the intensified exploitation of migrant labor, including children, and of course, trafficking. And 6, commodification and thus disposability of migrant personhood and migrant bodies, which includes the migrant deaths at the border and en route. This is part of the commodification and the disposability. This includes mass and individual, quote, kidnappings, which should be understood as forced disappearances, migrant massacres, child and sexual abuse and trafficking, etc. All of this is what is being consolidated and reinforced by current trends in the US and beyond, in the EU, in East Asia and their peripheries. All of this as refracted, reflected, and intensified through neo-fascism, racism, xenophobia, great replacement theory, etc. All of this magnified as we speak. This is what we have been developing collectively through the International Tribunal of Conscience of Peoples and Movement. This is what is reflected in its version almost 10 years ago in our book, Human Rights, Hegemony, and Utopia, which is available in a much more affordable form through Haymarket. This is what we see in Trump 2.0. It's important to stress the reactivation of the Alien Enemies Act. The Korematsu decision of 1944 was founded on the Alien Enemies Act. It's important to stress the Trump doctrine of unitary executive power. We can come back to all that and what that means. It's important to talk about the militarization of immigration enforcement within US borders and beyond, the deployment of troops, of course, on US territory. It's no longer US Marines invading Haiti, it's US Marines invading LA. It's the detention camps in places like the Everglades, but also at military bases like Fort Bliss. It's the externalization to places like Secot in El Salvador, explicitly through torture and forced disappearances, but it's also the reactivation of Guantanamo. It's places like military bases in Djibouti, but also South Sudan, Eswatini, Rwanda, etc. We can come back to Robert Jackson's dissent in Korematsu and why Korematsu is now being revived. And then talk about the irony of Jackson's role as the chief prosecutor at Nuremberg, where he insisted that the Nuremberg principles, in effect, were also applicable to the US, and how that laid the basis dialectically for the Russell Tribunal and for the Permanent People's Tribunal, et cetera. And let's speak, as we close, I'll close with this, that there used to be all this rhetoric about a Gulag archipelago in the Soviet Union. Well, now we have to speak about a Trumpian archipelago around the world, and how the US is striking deals already with at least 19 countries, but there's another 38 on the table: Angola, Benin, Costa Rica, El Salvador, et cetera. The list goes on. And El Salvador and what happened there with Secot is simply the prototype. And these are just images from the struggles that continue. And there's this Blue Triangle campaign that Witness of the Border is developing, pressing the analogy and stressing that we shouldn't refer to the Everglades camp as alligator Alcatraz, but as alligator Auschwitz, and the ways in which resistance is developing in places like Camarillo, California. Thank you.
Thank you so much, Camilo, for masterfully centering our discussion in racism, xenophobia, and the neo-fascist authoritarianism, and discussing the imperative of decolonization. Next, we have Nicole. Go ahead.
Thank you so much, Marjorie. And that, Camilo, that was Professor Bustillo. That was really, really inspiring. Thank you for laying that context. I was taking notes, and I have to say, I hadn't, as many years as I've been thinking about these issues, I hadn't really used the concept of migrant genocide. And I think that when you speak to Haitian migrants that are trying to survive in the various countries they're passing through, they would agree with that terminology. So thank you for just pulling this all together historically with so many different contexts. I want to thank Marjorie for inviting us and hosting this panel, and Aaron for providing all of the logistics. And it is really a pleasure to be on this panel with Natasha and Camilo. Those of you who, you don't have to live in the United States to hear about what's happening in the interior and at our borders with the new administration this year. And, the recent executive orders that Trump has passed in 2025 are really terrorizing immigrant communities. And at the same time, access to courts and due process for immigrants and even non-immigrants is really eroding. And so this combination puts us on really terrifying footing for safety and security of people and their freedom of movement, as Camilo so eloquently put the context for, but also just for everything, basically every fundamental right that we as Americans and individuals living in the United States are feeling. Just to give sort of a brief overview, highlight overview of what's happening in the United States. I put together about 5 different buckets of policies that are being implemented by the Trump administration right now. The first one is their aggressive use of expedited removal. And what that means is it's truncating, almost obliterating people who are asylum seekers access to seek asylum in a meaningful way with due process. And we know under international law that there is the right to asylum. Almost all administrations in the United States have violated that right in one way or the other, even though we're signatory. But this, of course, is sort of one of the worst that we've seen. And that's, people, they're taking people off of the street who are immigrants or they suspect of being immigrants. And they are adjudicating their asylum claim within a few hours, if at all, and then deporting them, sometimes to their country of origin, sometimes to another country. So that's one sort of bucket. They're also using racial profiling and excessive force. As I mentioned, we've all heard those stories, particularly in Los Angeles area, but it's not just Los Angeles. Now that now that there's more resources, more funding, unfortunately, for this immigration apparatus, that, as Camilo mentioned, was created post 9/11 in the United States, they are going to be going to more and more cities. So they're picking up basically people who are brown or Black, that might be an immigrant. They're often picking up people who are long-term residents, who have green cards, people who are citizens. And so that racial profiling and excessive force. The third is ending protections that are authorized under the Biden administration for immigrants to come in. So President Biden was by no means an angel in immigration. The organization I worked with, Haitian Bridge Alliance, when I was legal director, we sued the Biden administration multiple times. But one thing that he did do was that he granted humanitarian parole in a number of situations for Ukraine, Haiti, what they call the CHNV parole program, Cuba, Haiti, Nicaragua, and Venezuela, giving them humanitarian parole for 2 years. One of the reasons he did that was because he saw this influx of migrants coming to, and I say migrants and refugees, asylum seekers, saw them coming to the border and wanted order at the border, was afraid of the Fox News blowback from people coming to the border, and so would make a point, did 2 different things, would set up a system where people could make an appointment. Usually it ended up being from anywhere from 30 days to a year in advance. And then they had a chance, ostensibly, to do background checks and let them in. The other one was they could apply for this humanitarian parole from their country of origin, if it was in the 5 countries that I just mentioned, and then they'd be able to come in. So Trump took away the legal status for those individuals. He's also terminating temporary protected status, which is sort of like a humanitarian parole for many countries, including Haiti. We'll get more into that. He also is adopting these policies in aggressive manner that's undermining all sense of security. So he's going after, for one of the first things he did out of the gate was go after unaccompanied children, taking away funding for individuals who are helping children who've been traumatized. Birthright citizenship, he immediately did an executive order going after that. Also legal permanent residence, undermining, even if they're involved. And all of this is based on their political speech, association, basic human rights, but also even First Amendment under the US Constitution. And the 5th is persecuting immigrants, right? Taking away their student visas, which we saw, or even their green cards, and putting them in removal proceedings immediately. And again, all of this is based on political speech and association. And so as Camilo framed, deporting people, putting them in removal proceedings, denying their asylum and immigration opportunities, is historically been used as a pretext for fascism. It's creating an enemy, us against them, and an excuse to use these policies and laws to gain fascist control. And it's justified, right? They're scapegoating these people as illegals, not worthy of American due process or even humane treatment. When we look at, thank you, Erin, or when we look at their not worthy of American due process or even humane treatment, when we look at their conditions that they're kept in. So this is all deliberate. And as Camilo mentioned, we've seen this before, right? This was used in Nazi Germany. This was used in Trujillo's Dominican Republic against Haitians. This was used in the United States in the 40s and 50s in McCarthyism. And now Trump is reusing this. This is who the United States is. Let's be clear. This isn't just a new wave brought in by Trump. This is who the United States has always been and continues to be. They were just a little bit dormant. So with this backdrop, I want to talk about Haiti. Erin, you can start the slideshow now, please. I want to talk about Haiti and how, in particular, we all remember August 2024, which was in Springfield, Ohio. There were rumors circulating by President candidates, Trump and Vance, that previewed how they were going to treat Haitian immigrants. They said that they were false accusations that they were eating dogs and cats. And they were using this to disparage them and turn Americans against Haitians. This is not the first time the Haitians been used as scapegoats. If we'll remember back in the 1990s, Haitians, there were the 4 H's of the causes of HIV/AIDS, Haitians were used as one of those 4. There was absolutely no medical evidence that, US HIV/AIDS was more prevalent in Haiti, that people were more susceptible to it, but it was an easy political excuse. And so what Trump did was he previewed exactly how his administration would treat Haitians. And he followed up on what his promises were, which was taking away the humanitarian parole that I mentioned before for Haitians and stripping them of their temporary protected status, which allowed them in the United States with work authorization and freedom from deportation due to the conditions in Haiti that are unsafe for them to return to. And Haiti had had TPS since 2010 after the earthquake of January 12th. That was the worst natural disaster in modern history, killed more people than in any other natural disaster, of over 200,000, and completely gutted the capital. And so rightly, TPS, we had to fight for it, even under Obama, but eventually they did grant TPS, and it's been renewed ever since and even redesignated, except for the last Trump term in 2017. So he said he was going to terminate it, and he did. And so meanwhile, what I want to talk about is why did Haitians leave Haiti for the US, and how did they get here? To put this into context. The UN estimates that armed groups control about 85% of Port-au-Prince, and they are quickly going into the rest of the country, into the rural areas. Haiti is about the size of Massachusetts. So if you can imagine, it's not that hard to get to other locations, and they're quickly controlling others as well. As a result, over 1.3 million Haitians, which is over 10%, there's about 11 million Haitians total, are currently internally displaced throughout the country after being left homeless by gang violence, many displaced multiple times. Most of the country does not have access to electricity, fuel, schools. Children are out of school, or jobs. The UN highlights a severe deterioration in food security across Haiti. More than half of the population, 5.7 million people, are experiencing acute food insecurity. Of these, over 2 million suffer from high malnutrition rates. There was a warning last year that there would be a famine coming in Haiti. This prolonged period of instability has rendered all levels of government incapable of protecting the rights of victims of violence in Haiti. Women and children are, as always, the most vulnerable. And so with no hope, right, people have been leaving Haiti, because this isn't something that has happened overnight. This has gotten a lot worse when President Jovenel Moïse was assassinated in 2021, but this had been building for years. And so starting at around 2015-16, Haitians started leaving and going on a migrant journey. This journey, and we can see the map on this slide, is taken by, as Camilo mentioned, a lot of Africans have been forced to flee as well. This is the route of Black migrants. This was the route of Black migrants for years. Venezuelans have joined this route. There are now more Venezuelans taking this route than Black migrants. But at one point, Haitians were the biggest majority of people taking this dangerous route, where they would get a visa or some way of landing in Venezuela, in Chile, or in Brazil, and then they would travel through 7 to 11 countries up through almost all of them with the end goal of getting to the US-Mexico border and getting into the United States. And that's because they've got family in the United States. And that's because they see the United States as a stable country where they can send their kids to school, where they can get medical care, and where, most importantly, they can get a job. And they have family, they have connections, so that's where they want to go. But many worked in Brazil or in Chile. Brazil had the Olympics. They had the World Cup. that they were building for, expanding, and they needed the labor. And then, just like most labor situations, migrant situations, when they were done needing the labor, the projects were over, they didn't want the immigrants any longer. And so, next slide, please. Just look. And actually, next slide after that, please. Thank you. So these are the issues, conditions that Haitian migrants face as they travel through the Americas. They face anti-Black discrimination. They're going through countries like Chile, where there are very few Black migrants. So everybody knows who the Haitian migrants are. They're speaking a different language. They don't speak Spanish. And they are not sort of Latino descent. And so the discrimination against them, the racial slurs against them in a lot of these countries is extremely painful and very difficult to navigate. But it also shows up systemically as they are as they're being bribed by National Guard or immigration authorities or just police. It shows up in their never being offered to apply for asylum in the countries that they're going through. It shows up in the way, if they do apply for asylum, that the immigration system processes them, right? When you do an asylum interview, for example, COMAR, the Asylum and Refugee Office in Mexico, Haitians are often deemed, just like in the US system, uncredible, unbelievable, lying. And if you're not going to be deemed credible in an asylum interview, you're going to lose. So these types of racism and bias are pervasive and are with them through their entire experience. There's also violence and exploitation from cartels because they stand out. It's easy to know that they're the migrants. And there have been times when they are kidnapped more and really targeted for these crimes along the US-Mexico border, but when they're crossing the Guatemala border into Mexico, into Tapachula, Palenque. Housing is tricky. Imagine, nobody wants to rent to Haitians. So finding stable housing and not being charged 2 or 3 times what others are being charged. They're being charged more than their Venezuelan migrant counterparts, particularly in Mexico, but in other places. Lack of medical care. I'll give you one anecdote. I spoke with a woman, her husband, when she left Haiti, he had been a law student, super bright, young couple. And she was pregnant. It was her first child, and they were in Chile. They had to leave because, as a student activist, he was persecuted by the Haitian government. So they had to leave, right? So it shouldn't make a difference, but a good asylum claim. And she was pregnant. She was 9 months pregnant. She was young, thank goodness. And when she went to the hospital in Chile to give birth, and they spoke some Spanish, they were educated. Again, shouldn't make a difference. They went to the hospital and her water had broken and they denied her entry into the Chilean hospital. They wouldn't provide her any health care at all. And they forced her to give birth basically in the plaza right in front of the hospital in open air with no medical professionals at all. Her husband and kind people around helped her deliver. When the baby was born, because under Chilean law, they have a solis, so they did treat the baby, but they never did treat the mother. And this type of painful experience, when you're looking in the eyes of another human and they're not looking at you as a human, that harrowing experience terrifies people and it makes them want to leave the country. And so we saw thousands and tens of thousands of Haitians leaving Chile because of discriminatory treatment that they had been subjected to and or people had been subjected too. But even in Brazil, which is so multicultural and so diverse racially, anti-immigrant on top of anti-Haitian sentiment still pervaded. Let's okay, I think I've covered everything I wanted to cover on that. When I was at Haitian Bridge Alliance, we filed a number of reports trying to hold countries in South America and Central America accountable for human rights violations against Haitians. And Panama is another country that came up. Our biggest concerns with Panama, there's the Darien Gap that you all may have heard of that everybody has to pass through. And the Darien Gap, which is between Colombia and Panama, is this jungle of about 100 kilometers in length through thick forest. And it's gone through a few different iterations, but back in 2020, 2021, Médecins Sans Frontières, Doctors Without Borders, was reporting hundreds and hundreds of sexual assaults, gang rapes by unclear, nobody's researching exactly who the culprits are, but it seems like a combination potentially of Senafront, of sort of military within Panama, and perhaps they're scapegoating unclear indigenous communities, sort of gangs in the Panama area. So dozens of men, armed men with masks, would come and would brutalize groups of migrants from 3 to 4 people to 100 people. And they would sometimes kill, but often sexually assault. And so meanwhile, the Panamanian government was doing absolutely nothing about this. And instead, they were trying to take away authorization for Doctors Without Borders to operate in the Darien Gap, in Meteti and in the areas that are further into the gap, so that these reports of statistics wouldn't be offered. Healthcare was not given to women in French or Creole, Haitian Creole. So there was no language access. And so these numbers, of course, were so much lower. Médecins Sans Frontières was the only organization that provided some French and sometimes Creole. So they were able to get some numbers. There was very little efforts at prosecution of these crimes. It's as if crimes that happen against migrants, it's like a deterrence. Well, it's a tough journey, isn't it? Maybe you shouldn't come. It's a deterrence to migrants, as if, and almost using it against them of, wow, how could they put their families in harm's way, knowing that there is these potential violence that they could be victim to, as if migrants have a choice, as if they have a choice to flee where they're coming from. Just looking, let's go back to the prior slide. So then it comes to the United States. And I mentioned some of the things in the United States, but one thing that we just can't not mention, the photo on the right upper corner, Haitian refugee, went viral. Many of you saw. That gentleman's name is Mira Joseph. And he's an immigrant from Haiti who, it was his daughter's birthday that day. And he needed to cross back into the city in Mexico. He was under the bridge in Del Rio, along with between 10 and 15,000 other Haitians, most of them Haitian, not all. And he needed to go back into Ciudad Acuña on the Mexico side because he wanted to get her a dessert, like a popsicle or something for her birthday, because she was trapped under this bridge while they waited to apply for asylum in the United States. And as he was coming back with lunch, food and a treat for his daughter, this is what happened to him. He got stopped by Border Patrol, and they ripped his, manhandled him, ripped his t-shirt, and whipped at him with the horse lanyard. We found him, and we filed a lawsuit. He was deported, of course, immediately, because you have to hide the evidence. But of course, he was put in detention and then deported. But we found him, and we filed a lawsuit against the Biden administration on his behalf. He also has a Federal Tort Claims Act filed against him. And we were able to get him back in the United States under the CHNV parole program. And that, of course, parole has been taken away from him. TPS they're trying to take away from him. I mean, this is what people on a day-to-day basis, what people are facing. In the meantime, though, right, the Biden administration granted over 100,000 Ukrainians were going to get status easily, and they didn't have to go through crossing a river, very dangerous river. People drowned in that river. You can see the river crossing from Ciudad de Cuño into Del Rio, Texas. They could just fly in. So disparate treatment against migrants, including Haitians, from the very beginning. Hello, Carrie. Let's move in. Some of these slides, I'm looking at the International Human Rights of Migrants slide 5. Some of these slides I just put in so that you would have them. This PowerPoint presentation will be available. I'm not going to go into this. I feel like Camilo covered this so well. But needless to say, there are, of course, international human rights protections. And it protects against non-refoulement, as Marjorie has mentioned. But it also protects against treatment. You've got to treat migrants as humans. This may sound, novel, unfortunately, to countries that people are passing through. I do want to recognize some pretty outstanding work that is being done by human rights bodies. The Inter-American Commission did issue a gorgeous resolution, I think they call it, in 2021, that talks about how Haitians should be treated, that the community, the South American, Central American countries of the organization states, including the United States, need to come together at this moment of crisis for Haiti and provide them with a temporary, at least, if not permanent access, of course, to asylum, but at least some type of humane treatment, but also immigration status. And so, so that's there. We tried in the Cartagena meeting that happened in Chile last year. There was a meeting plus 40. We tried to get language in there, which they've done before, to single out a particular country as deserving of the Cartagena definition of refugee that would make it easier for countries to give refugee status to Haitians, and they declined. And we did a lot of advocacy, and they declined to mention Haiti specifically. And Mexico has given it to Venezuela. Mexico has given it to Honduras and to El Salvador. Brazil has given it to Venezuela. Brazil, to their credit, has issued humanitarian visas for Haitians, but they're not applying the Cartagena definition to Haiti, even though legally they should and certainly could. Why is that? The conditions, and I realize Venezuela is very difficult, but I was speaking at an event with researchers from across ACNUR, from across UNHC, Organization of Refugees, about country conditions. And this was in Mexico City, and they had two sets of panelists, one on Venezuela and one on Haiti. And I was speaking with a human rights lawyer from Haiti on Haiti. And Venezuela went first, and then Haiti went. And afterwards, people were like, we had no idea it was so bad in Haiti. Oh my God, what can we do? Da, 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 da. And so we said, apply the Cartagena definition to Haiti. Was never done. And so the conditions in Haiti are as bad, if not worse, than in Venezuela. So the only reason is racism. And this is what we're dealing with, and this is what Haitians are dealing with systemically, the high political level, but also you can imagine then how that manifests on a day-to-day basis in their employer, at the hospital, in the asylum office of whatever country they're going to. Let's go to slide 6. For the United States, again, this is just a list for the academics out there who want to know more. These are previous policies just under the Biden administration. Again, this isn't new to Haiti. Let's go to to Trump. Let's go to the slide 7. Just showing what's available in here. These are, violations of the right to seek asylum that have been created. These are the impacts of that on migrants in Mexico. Camilo mentioned Mexico. We've spent a lot of time in Mexico because there is a lot of discrimination against Haitians in Mexico. Go to slide 8, please. I want to talk a little bit about root causes of Haitian migration. Why did Haitians leave Haiti? Slide 9, please. This is just a brief history of Haiti, but it starts with 1804 and the independence from the slave revolt. And the New York, you can't talk about Haiti without talking about the pride and courage of Haitians in declaring and being the first country in the world to end slavery, to abolish slavery, and to rise up against their slave owners, the French, and declare independence. And so go to slide 13. As Frederick Douglass said, Haiti is Black, and we have not yet forgiven Haiti for being Black, right? The fact that they were the first country to do that, 1804, count back. When was the Emancipation Proclamation in the United States? 1863, 1864, it took effect. That's a couple generations of slave owners who didn't want slavery to end because they were profiting off of it. So the US government had to, as well as the French, as well as the Spanish, as well as everybody, Britain, had to declare Haiti person non grata or country non grata, had to stop all trade with Haiti, even though Haiti had been the most prosperous colony short of the United States. The most prosperous. It's only the size of Massachusetts. Because of the hard work, unfortunately, and because of the beauty of the land, the ability to grow cash crops like indigo and coffee and chocolate and sugar. Let's go back up to slide 10. Thanks for your dexterity, Erin. So when Haiti became independent in 1804, no government recognized it. But meanwhile, France threatened to reconquer Haiti unless they paid $150,000 for the loss of their property. What was their property? What was their chattel? Was it their homes? Was it their plows? No, it was their people, it was their slaves, it was human beings that they considered their chattel. That's what Haitians had to pay for. Slide 11. And so that debt went from French government to French bank to Citibank, ended up buying that loan in the early 1900s, and it was finally paid off in the 1930s, with all the interest levied at 10 times the annual rate of the Haitian government, was what that independence was, and to the tune of about $21 billion. For people who are interested in this, there's a New York Times expose from a couple years ago that's just incredible on this. They were not the first to find this story. They consider themselves the novel people who figured this out. We've been talking about this for centuries, but they did do a beautiful expose on it. Slide 12. And as the U.S. history mentioned, or excuse me, the history of Haiti mentioned, the U.S. then came in as they were going around to Cuba and Puerto Rico and Guam and Hawaii and all these states saying, okay, the European colonists have gotten out of these areas and we want in. Where can we go? They, 1915, went into Haiti. The Marines came in and they took the gold, changed the constitution so that foreigners could own Haitian land, helped assassinate a president, and did what the United States does when they go into countries. And that occupation is extremely significant for Haitians, and it lasted for about, if I'm not mistaken, about 19 years or so. Slide 14, please. And we've all heard of Papa Doc and Baby Doc, the Duvalier dictatorship that controlled Haiti from I'm so bad with dates, but I think from the 1950s through the 1980s. And here's a photo of Papa Doc, François Duvalier, and Nelson Rockefeller, all the way into 1969, right? So like so many dictatorships around the world, if the United States hadn't been giving it money, hadn't been giving it the prestige and validation at the United Nations and in the international realm, it wouldn't have existed. So the Duvalier dictatorship, the combined 29 years, was considered one of the most dangerous, worst dictatorships in the 20th century. And that's saying something because there's been a lot of bad dictatorships. And the United States supported it. Slide 15. There's also, and we won't go, I mean, I have a whole class on this. We won't go into this. I just want to show, then there's, US domination, neoliberal capitalism through international financial institutions and other economic ways that the US continues to dominate Haiti. Number 16, please. This is a photo on the right of former President Michel Martelly with Hillary Clinton, and at the bottom with Proval, René Proval, former president, and Hillary Clinton. They also intervene politically still, right? We see this everywhere. They put their people in office. They put their thumb on the scale. So why am I showing you all this? These are a lot of the root causes, right? Why are Haitians fleeing? And as when we talk about decolonization, as Camilo has mentioned, former special rapporteur to racism, Tendai Ashime, that when she talks about colonization, she talks about the very countries that colonized, imperialized, control countries where people are fleeing from. Like they're the colonial countries are the ones that control these countries and limited people's mobility from the get-go. And then now in the second, third wave are denying their right to movement, their sovereignty, their autonomy, their liberty by keeping them in their country and refusing them to allow them to leave when their house is on fire. So we lit the match to make the house on fire for Haiti and a lot of other countries. And we now are going to keep them in that house and not let them go. And what Trump's done is he's reversed the policies that Biden enacted that said, all right, we shouldn't make you go back to your house. You're already in the United States, or over, I think it was about 120,000 or so Haitians came on the CHNV program directly from Haiti into the United States. We're going to make you all go back. We're going to take away those temporary measures that allowed you to safely seek asylum in the United States. And so this is what Tendai Ashime talks about when she talks about decolonization. Often she thinks about immigration policies, that there are two. There's racial, when we think about racial borders, we're thinking about territorial borders and political borders. And the territorial borders are the you can't cross without a visa. And then there's the political borders. And these are defined by race. These are defined by it's excluded, it's being exclusive, it's excluding people able to enter into your country. And so it's this mixed with the fascist desire to scapegoat this population and gain further control so that they can have all these other policies that they want to, right? So that we can have this this autocracy, this oligarchy that where businesses can profit and, you know, et cetera, whatever these ideological, financial, capitalistic goals are, it's politically controlling borders, the movement of human beings, in order for the gain and the control. And I think we would argue in some ways this is just no difference from the colonialism and the slavery that was practiced for hundreds and hundreds of years prior to this, that is just part of white European hegemony and rule. And so the question then is, what can we do about this? And I just looking at, before we get to that, I think I just talked about that. So let's get to slide 18, please. So what are some solutions? We now understand what the problems are. What are some solutions? One thing that we, human rights lawyers have written about a lot in the United Nations is about the use of human rights-based approach to development. And I would call it approach to development, but also everything. So making sure on a micro level that any program we have in another country, whether it's the USAID, which no longer operates, and a gentleman who taught me, Jeannie Mayer is here, and she knows him very well. I met Mario Joseph, as a Haitian human rights lawyer who just unfortunately passed in March of this year. And his biggest solution to this would be the United States, Europe, Canada, the UN should get out of Haiti. ABBA United Nations, ABBA United States, get out. And that there shouldn't be, that is a colonial for any of these countries to be there. So that's the first thing that Mario would recommend. And to the extent that there are any organizations that are there, this is, I would say, use the human rights-based approach for making sure those projects are effective at all. Slide number 19. In addition, countries in Americas need to come together and welcome Haitians and protect them from crime rather than criminalizing them and leaving them vulnerable to violence. We need to halt deportations to Haiti, decolonialization, recognizing the root causes, changing the foreign policy so that Haitians don't want to leave Haiti. Haiti is gorgeous. Haitians want to be in Haiti. So change the root causes, address the root causes, but in the meantime, halt deportations to Haiti. Coordinate with humanitarian legal groups on the border of the US and Mexico to establish fair and humane systems for receiving asylum seekers, but this includes Panama, this includes other countries as well. I mean, the basic is just looking at other ones. And the other one is, this includes the United States as well as other countries throughout the Americas, is we need fair asylum access with language assistance, particularly for Haitians, but also people from Africa who speak so many different languages. We need access to lawyers. We needed to end the system of expedited removal. We need bonds. So I mean, we should not have any detention system at all. I will note that Haitians, the reason that there is a US detention system in Haiti that was established in 1981 under President Reagan was for Haitians, because Haitians were fleeing. Remember I mentioned the US involvement in the Duvalier dictatorship? Haitians were leaving the Duvalier dictatorship. So how does on boats? And how does Reagan respond to this? He builds prisons to criminalize them and hold them, and gave them almost no access to asylum, and then deported them. So that was for Haitians. So we need to take down those, we need to not criminalize asylum seekers, and especially their families and their children. So we need to get rid of those prisons. But in the meantime, we also need to have relevant, accessible bonds to get them out, because you cannot defend your life for asylum from detention. And we need to, of course, stop deportations. I keep saying that, but it's really important. I'm going to stop there, and I'm excited for the conversation afterwards.
Thank you, Nicole, for expertly explaining the cruel U.S. immigration policies, now even worse under Trump, for highlighting the plight of Haitian refugees and how to utilize the human rights-based approach to remedy these atrocities. Thank you so much. Next, we will hear from Natasha.
Hello, thank you for the invitation. Yes, thank you so much, Nicole and Camilo. I mean, so much has been covered. I really don't know where to start now. So yes, I feel grateful for being in this panel, because it's very important to remember the similarities all over the world. I'm really impressed, but negatively impressed about the similarities of the situation of migrants everywhere. So while listening, I was thinking of my title is Combating Criminalization of Migration and Border Violence at Europe's Sea Border. And Challenges and Small Victories. I was thinking about why I said small victories. For the people that we are fighting for, there are big victories. And for us as human rights defenders, they are as well big, but there are so many other battles that we can only fight and not be sure about if we are successful or not. And there are also many disappointments. So yes, this is why I said small victories. And then while listening to Nicole's presentation, I was thinking another good title would be The Only Reason is Racism, covering actually everything. And another question that occurred to me was who profits from border violence and violence against migrants in the end? I think it's a very big question to not forget about it. So, as this has been said, I'm a Greek lawyer. I work with the legal center Lesbos, and I will presenting as part of, I will speak from my work experience in the field of migration as part of the Legal Center Lesbos since 2016. Legal Center Lesbos, very quickly, is a grassroots organization, a small, very small NGO, a team of lawyers and legally trained people and interpreters who have been providing free legal assistance to migrants and refugees since 2016. And we are based on the Greek island of Lesbos. So when we started in 2016, I have to go a little bit back also to explain what is on stake today. So our main focus was to support people on the move who crossed from Turkey to Greece in order to seek asylum in Europe. Since then, Greece was seen as an entry point, and the aim was to get to North Europe, Germany, Sweden, Holland, UK, France. And then the so-called EU-Turkey deal was made back in March 2016. And this had as a result that people got stuck in Greece, and more particularly on the Greek islands. I think many of you must have heard about the notorious conditions in Moria camp on the island of Lesbos, where people had to stay and wait for the asylum procedure to be completed. So we supported people to accelerate their asylum procedures, to have their vulnerability assessment completed, to prepare their asylum interview, to get transferred out of the camp. And we visited them when detained and objected against detention orders. We supported people in their family reunification procedures. We appealed against negative decisions regarding their asylum claims. And in general, we were helping people to have access. It was all about access to the Greek asylum system. Because apart from the unhealthy and inhuman living conditions in the camps, people had to face tremendous bureaucratic obstacles, starting with lack of interpretation and many other obstacles that amounted to denial of access actually to the procedure in a discriminative and racist approach, dismantling people from their human existence. There are too many examples regarding this dehumanized behavior, which I recall from the first years when back until 2020, when the Moria camp was burned down. And at that point, Moria camp had 13,000 people being stuck there. And there were numerous EASO officers that Europe placed in the asylum service back that days on the island to bring order. So I recall officers standing inside the area of the asylum offices within the camp, and hundreds of asylum seekers squeezed like sardines in front of the iron fence that as a like a border between humans and non-humans, in order not to miss to hear their name or a number corresponding to their names. And the officers, they were literally barking at the people. So people were queuing for hours, endlessly, for days, in case miss to hear the number, or in case the time has passed and the office closed. So postponements, delays, endlessly queuing, as well as for bad food, for medical support, and for the simple question. Unaccompanied minors exposed to the Moria jungle or kept illegally in detention. So at that time, legal aid was very crucial, as lawyers had definitely easier access to the asylum service and in general to the Greek authorities, and were more or less respected. The difference in how people with a lawyer were treated compared to people without was striking. 10 years after, still people are contacting me and expressing their appreciation of the support at that time back, which felt for them like getting their lives back. And that was the beginning. So the content of our work kept changing all these years, adapting to the needs of the people on the move, but also to the continuously changing environment on local, national, and European level, and of course, a highly politicized field of work. Due to the increasing intensification of criminalization that was already mentioned of migration and migrants, at least the last 5 years, which has gone hand in hand with the pushbacks at the European borders, and more specifically in the Aegean Sea, in the Mediterranean, or at the Evros border in the north of Greece, we have taken on legal representation in criminal proceeding against migrants, and we also support victims of violent pushbacks in lawsuits against the state on a national and international level. Starting during Corona 2020, where a concrete modus operandi of pushbacks at sea was introduced and continues until today. The Legal Center Lesbos has gathered hundreds of testimonies from survivors of border violence. people started to contact us seeking for legal remedy for the human rights violations they suffered as victims of pushbacks. In one case that we decided to litigate back in March 2020, according to the testimonies and available evidence, 31 people, including many children and women, arrived on the Greek island of Symi, where they were kept in unofficial detention without ever being registered, deprived of all their personal belongings, left for days without food and water, sleeping in an open space without medical care for people in desperate need of it, and then forced with the use of violence in a motorless life raft, and then abandoned in the middle of the sea. From the testimonies and the reaction of the Turkish Coast Guard, who eventually saved them, they were the lucky ones, and the Greek authorities, it looks like it was the beginning of the specific modus operandi of violently conducted pushbacks and using these motorless life rafts against people seeking protection in Europe. Until today, and despite also the very recent European court decisions on that matter, Greece is still denying that pushbacks are actually happening. More analytically, in January 2025, the European Court of Human Rights delivered its first rulings on pushback allegations against Greek authorities in two cases. It's Air versus Greece and GRC versus Greece. These were part of a broader group of 32 similar cases against Greece concerning the illegal expulsion of refugees to Turkey, including two cases we are representing as Legal Center Lesbos and that remain pending. These decisions were issued following a public hearing, which is not really, is a rare thing to happen, on June 2024. While the court, for the first time, it found multiple violations of the European Convention on Human Rights in these cases regarding pushbacks, it declares the second case inadmissible. Both applicants alleged that after arriving in Greece from Turkey, they were detained, had their phones confiscated, and were forcibly returned to Turkey. These are practices consistent, as I mentioned above, with the modus operandi of Greece's well-documented systemic pushback policy. The court acknowledged serious indications of this systemic practice of Greece in carrying out pushbacks at both its land and sea borders at the time of the incidents, but confined its findings to the specific cases, saying that there was in the one case insufficient and supposedly contradictory evidence that the applicant had actually been subjected to the specific pushback incidents. Very frustrating. While the ruling in Air was an important step, of course, in recognizing this abusive practice at Greece's border, combined with the second decision, the court risks reinforcing impunity by imposing unreasonably high evidentiary threshold on victims in a context where Greek authorities systematically prevent the collection of evidence. Of course, it was said before by Nicole as well, how evidence is hidden, and also by disappearing actually of the people themselves, making them not visible, including through the confiscation of phones during pushback operations. In January 25, the Legal Center Lesbos, in collaboration with Fitilia, a local group that collects and shares stories from people on the move, started publishing a series of anonymized testimonies to show that behind every pushback are people. They're risking everything to reach Europe. These stories reveal not only the brutality of EU border policies, but also the courage of those who resist them. They are a call to action against the violence of Fortress Europe. You can find this in our website in the February and March stories, if you are interested to read more about it. So, yes, what we have. On the one hand, we have the pushbacks. And on the other hand, we have the so-called smuggling cases, where people, after and if they have managed to survive from border violence, they are accused of facilitating unauthorized entry. Convicted in court proceedings that systematically fail to ensure a fair trial for them, they end up in Greek jails convicted with heavy sentences of dozens years. These people are the second largest population in Greek jails right now. In these cases, people are accused for smuggling only because at some point of the journey they steered the boat to protect themselves and their families in most cases, and to survive because many of the people, or most of them, they cannot actually swim. And also, they are accused without it being necessarily, according to Greek law, to prove any gain. This is not being necessarily according to EU law, but in Greek law, they don't have to prove any gain of profit. So only with steering the boat, or many times just being a passenger. It is common practice when boats carrying migrants seeking refuge in Europe, the Greek Coast Guard selects from each boat intercepted or from each boat reaching the Greek territory without being pushed back, often with the use of violence and randomly, for example, by asking who speaks English, by putting pressure to other passengers to testify against another person in the boat. Without sufficient or valid evidence, they pick one or two people against whom criminal charges are being pressed always. Then, after this only, the rest of the passengers are being transferred into a first reception and identification center, the so-called hotspots, for the initial registration and in order to start procedures for requesting international protection. As I said, Legal Center is supporting criminalized migrants. And of course, I said that I will also speak about some victories. So we had one recently, a significant one, legal victory, in the Mytilene courts on the island of Lesbos. AH was acquitted, a Palestinian refugee from Gaza. He was acquitted of charges of smuggling, causing a shipwreck, and disobedience. These charges were stemming from a violent Coast Guard attack back in September 2024, in which his boat was capsized and HA was beaten so badly he required hospitalization. The court dismissed prosecution testimony entirely when the Coast Guard witness, which are always, or not always, but almost always the only witnesses in these trials, failed to appear. And they failed to appear because there was proof about the beating and the violence used. While survivor statements confirmed HA was not piloting the boat, but trying to save lives during this attack. This acquittal not only vindicates AH, but also prompted an investigation into possible torture by Coast Guard officers in a case still pending before the Greek Naval Court, marking really a rare moment. And I must stress this, is a rare moment of judicial accountability in relation to border violence. In one other incident, on the 3rd April this year, in which 8 people were killed in a shipwreck off the coast of Lesbos, Testimony from survivors indicate that the boat only sank after being intercepted by the Hellenic Coast Guard. Following the shipwreck, one survivor, whose wife and one child were killed in this shipwreck, he was arrested and charged, as mentioned, with causing the shipwreck and smuggling. Together with the organization RSA, Legal Center Lesbos is representing the survivor in his criminal charges. The violent tactics of the Hellenic Coast Guard continue to be documented. And, of course, they force people on even more perilous journeys. With the increase in arrivals via the Mediterranean, Greece is already seeking to make a deal with Libya, because this is now the new route from Libya to the Greek island of Crete, to attempt to curb migration flows from the African continent. And Prime Minister Mitsotakis announced in June that Greek Navy ships are proactively going out of Libyan territorial waters, controlling flows of illegal migrants. A crackdown on migrants arriving to Greece on this migration route has already started, with the suspected drivers, often young men or boys fleeing Sudan, systematically arrested again for smuggling. Also, in relation to the smuggling cases of Sudanese people being accused, lately a new trend has been introduced into the Greek courts, the so-called plea deals, where accused migrants, in order to get a softer treatment and to receive a lower sentence, are obliged to accept all accusations against them, as it seems the only option to spend less time in Greek jails. This decision, apart from asking them to admit a crime that they have not committed, has a negative impact in their asylum claims and deprives them from a chance to fight in court for their acquittal. But given that it is an uneven fight and wins are exceptional, people choose more and more to go with the plea deal, as they are in a way expected from the court to do. This practice has been in particularly witnessed in the courts of the Greek island of Crete, as I said, where we have this significant increase in arrivals since June 2025, indicating a change in chosen migration routes. And last but not least, of course, NGOs who offer support to people on the move are also subject to criminalization by the state, as being seen as facilitators of illegal entry, called even in public discourse traitors or Turkish agents by specific far-right groups and politicians. Despite all of this, and trying to ensure people have access to asylum procedures in Greece, as they have the right to, LCL provides the last years the so-called emergency legal assistance. So people who have just arrived on the Lesbos island can call at the publicly available phone number, and then they can request support in gaining access to the asylum procedure. Legal Center Lesbos then collects all necessary information and communicates them to the directly to the Greek authorities. So they can't say these people are not existing, or they are not there, or they are making up pushbacks happening. So it's communicated to the Greek authorities directly, to the UNHCR and to the Médecins Sans Frontières and Frontex, with the coordinates of the refugees where they are. In order to effectively apply for asylum in Greece, it is essential that the Greek authorities are informed immediately. In a medical emergency, MSF provides one on the spot. People who arrive many times, they have no water, no food, they're physically or mentally weakened, or maybe injured or ill, and so they need this first aid very quickly. And in some cases, we also act as lawyers on site to accompany the transfer to the camp, where the asylum applications are then registered. And if necessary, and people authorize us to do so, we also apply for interim measures to the European Court of Human Rights, asking the court to intervene quickly in order to secure access and medical treatment. In June 25, we submitted such a request on behalf of a group of 29 people from Afghanistan who had arrived on the island of Simi, and whereupon the court ordered the Greek government to locate the refugees, to grant them access to the asylum procedure and medical care, and provide them with water and food. In an ideal, let's say, situation, or a normal situation, obviously, this kind of legal interventions deem not necessary. But just to highlight the reality we're facing, I would like to say a few more words about the context of our work in the migration field today as human rights defenders. Before I also say a few words on a concrete example of the Pylos, of the so-called Pylos case. Recently, the public and media discourse on refugees and migrants, especially in view of this increasing number, as I said before, of the arrivals of migrants via Libya on the Greek island of Crete, because it's a very well-known island, for a touristic island in the south of Greece, reflects a worsening climate of fear and polarization, a climate that has been further fueled by statements by representatives of the political leadership, political parties, and authorities. The use of derogatory terms such as illegal immigrants, the portrayal of newcomers as attempted invasion, and the misleading reference to the privileges and advantages of one population group at the expense of other citizens are just few examples that increase social division, which is, of course, an aim. They are narratives that help portray these people as a threat to society, exploit fear, damage social cohesion, and normalize, promote, and ultimately lead to an increase in intolerance and racist violence. This cultivates hatred of migrants. Every migrant bears the label of the illegal invader because they are poor and oppressed. In particular, due to these increased flows, we heard from the Prime Minister, Greece is not a corridor to Europe. We heard the new immigration minister, Plevris, in the Greek parliament speaking about population exchange in Europe through migrant invasion plan. We heard about planning drastic reduction in benefits for foreigners, up to the menu in the structure. It will be reviewed, including public statements such as border security cannot exist without casualties. And to be clear, if there are no deaths. This we heard. In his inaugural address as minister, Plevris openly stated that people entering Greece without authorization will have only two options: return or to be sent to prison. And he declared, in violation, of course, of Greek and international law, that no one entering illegally would be allowed to request asylum. This sentiment was shared by Prime Minister Mitsotakis, who stated in March, if someone enters Greece illegally, they will have to know that we will do everything in our power to return to their country of origin. NGOs, how they are treated. Other reply to critique received by opposition in the NGOs in the field, Plevris mentions, we are not going to let masses of people come here in boats under the guise of pseudo-humanism. Your pseudo-humanism lies in the so-called rescuers you support and in the NGOs. There is no altruism among NGOs. They make just money. This is how the work in the human rights field is seen and treated by the current politicians in the government. The previous minister, also far-right and known for his pro-Nazi past, was forced to resign over his involvement in one of the biggest scandals of embezzlement of European funds currently under investigation against Greece. And the highlight of this situation, 1 month ago, indeed, the Greek parliament passed an illegal and inadmissible legislative provision which provides for a 3-month suspension of the submission of asylum applications for people coming to Greece from North Africa and orders their immediate deportation without registration. As we know, or as one should know, the right to seek asylum and protection against refoulement are fundamental principles that must never be restricted. Both are enshrined in international and UN legal instruments that are above any domestic legal provisions. This has been already highlighted by institutions, by the Greek, the Greek Bar Association, the UNHCR, the Commissioner for Human Rights of the Council of Europe, and also Legal Center and numerous organizations. We have condemned, of course, this new legal provision and called on the Greek government to immediately withdraw this illegal legislation. So this is the hostile context where we also witness the complete lack of support by the Greek state to recognize Palestinian refugees. I need to mention this as well, because we heard previously about the Palestinian situation today. So there are family reunification cases now pending. And Greece, unfortunately, shamefully, is one of the countries that does not support any evacuation operations from Gaza. Although decisions are issued by the Greek Asylum Service, with big delays, but they exist, that accept family reunification applications and order the family members back in Gaza to present themselves to Greek embassies and consulates in Egypt. The responsibility of initiating the evacuation process lies with the countries hosting the families of these individuals, in coordination with the relevant authorities who issue the necessary permits. Greece, again, with cynicism and complete disregard of human rights, sends its message to the world, in which side of history it stands, and what can be expected or mostly not expected. It is very disappointing and frustrating because we are supporting family reunification applications. Every day, more and more requests, more and more people in despair asking, how can we support the evacuation of their families? And this is what we face from the Greek state. But in any case, we will not stop putting pressure and supporting the Palestinians' legitimate requests, instead of staying silent when this genocide continues to happen in front of our eyes. So now, very quickly, if I have few more minutes, I want to say some words for the Pylos case, because it is an example, it serves as a case study regarding all of what has mentioned above, as also what mentions from the previous speakers about finding scapegoats, about also trying to put all the discourse in a different direction and use and abuse migrants' rights and also migrants' rights and yes, make them look as criminals in the end. So as it been mentioned, I was one of the representing lawyers of the survivors of the pilot shipwreck and in the pending court against the Greek Coast Guard, which is pending in the Greek Naval Court. And I was also one of the lawyers who represented the so-called Pilos 9 in their criminal court proceedings. Many people have probably heard of the Pilos shipwreck, others may well not. So this happened 2 years ago on June 14th, 2023. One of the deadliest shipping accidents occurred in the Mediterranean when the fishing boat Adriana sank in international waters about 47 nautical miles off the Greek coast. Only 104 men survived, and it's estimated that more than 600 people, including all the women and children on board, perished. Although the European and Greek authorities were informed of its presence and the emergency situation hours before the ship capsized, 14 hours before, no rescue attempt was made. Survivors have consistently reported that the ship capsized only after being towed by the Greek Coast Guard. Only hours after the shipwreck, Greek authorities, instead of investigating the responsibility of the Coast Guard and Frontex, arrested 9 of the survivors themselves. So this case, the pilot shipwreck, has it all, or rather a lot of it. Cynicism, brutalization, total disregard of for human life. It's a racist crime, obviously. It's hubris. And what has been haunting us as a society, as I speak now for Greece, for the last few years, and is captured by the word cover up of serious crimes that leads to the death of people, with no consequence for those in charge, with complete impunity, with total lack of accountability, with no apology, with no consequence at all at the political level. And we speak about cover-up of other crimes that happened within Greece and concerning Greek people, like the Tempe train accident you must have heard of maybe. So here, at least 600 people died, the deadliest shipwreck in the Mediterranean. But still no justice has been served. So on board of this overloaded fishing vessel, known as Adriana, were around 750 people from Syria, Palestine, Egypt, and Pakistan. They were crammed on 2 decks and in the hold of the ship bound for Italy. Already after 4 days of sailing, and in any case from early hours of this day, the 13th of June, despite the very good weather condition, it had become certain that the ship could not complete its journey. Supplies and water had already run out. There were dead people due to the hardship. They were all exhausted. People were fainting constantly, and it was understood that the vessel was unseaworthy, carried no life-saving equipment, and had an unqualified and untrained people who were driving it, with the result that all on board were in dramatic and imminent danger of death. So for these reasons, already in the early hours of the 13th of June, they have been desperately seeking help, both from communication lines and activist rescue operations in the Mediterranean, as well as from coastal vessels that approached them on that critical day. Since this early morning until early afternoon, when the presence of the Adriana vessel was in the search and rescue zone of Greece, It was detected by the competent authorities by flying surveillance means of both Frontex and Greek authorities. The obvious danger that the vessel was facing was noticed by all, and the competent authorities were informed, while during evening hours it was approached by two private vessels, and then in the evening the patrol boat of the Greek Coast Guard approached the vessel. However, no rescue operation was activated at any stage, and you already must ask yourself why. And I think you know the answer. Even though it was absolutely necessary and urgent, and even though people had called in every possible way and by every possible means for their rescue. During the night, the vessel of the Greek Coast Guard that had approached, after initially indicating a course to the fishing boat by changing its direction, then attempted to tie it up and then tow the vessel in the same direction. Around 2 a.m. in the morning, the towing attempt caused the dangerous rocking of the fishing boat and finally its capsizing at 4 a.m. in the morning of the 14th of June. As a result of this, those on board either found themselves in the sea, desperately seeking for help. The help came only, again, hours later, or most of them were trapped on and inside the Andriana vessel, which after 10 to 15 minutes sank completely, dragging all of those who were trapped in the bottom of the Mediterranean Sea. As I said, only few hours later, in a very questionable process, 9 Egyptian survivors were arrested and taken into custody, with virtually no incriminating evidence against them and with essentially fabricated charges, statements of very dubious reliability. They were charged with illegal entry, with illegally smuggling and transporting third national countries to Greece, and causing the shipwreck, of course, and participating in a criminal organization. From victims of a shipwreck and survivors, before their clothes had dried, they were turned into perpetrators and taken into custody with the obvious purpose of covering up the criminal acts and omissions of the Coast Guard and their superiors, which led to the loss of these 600 people and could have been rescued. In the trial, 1 year later, it results to the acquittal. It was a very big moment, but maybe it happened, of course, because there were the legal arguments, the valid, and they were known from the start. They should have never been charged, of course. And also the court declared it inadmissible for the other two crimes, for criminal organization specifically and causing the shipwreck. These legal aspects, all, as I said, has been known from the start, but all submitted objections had been dismissed and the 9 people remained imprisoned until the trial date. Also, after their acquittal, instead of being released, the Pylos 9 were placed in administrative detention, reminding them they are illegal in Greece. These were objected to. These objections, of course, were accepted, and they were finally released on the 29th of May, 2024. 2 years later, and their asylum applications are still pending. So this is an example of how people on the move are welcomed and treated if they manage to survive. They imposed death politics at the EU borders. Until up to date, the complaint of the survivors of the shipwreck is also pending in front of the Greek Naval Court. It had been filed already back in September 23, by 40 survivors. Now they are more than 65, and also the survivors, but also family members of people who died. And with this lawsuit filed with the Public Prosecutor's Office of the Greek Naval Court in Piraeus, demanding everyone responsible to be prosecuted because the failure to rescue the people and because of causing the capsizing and causing the death to these people. So we are still waiting. I will not go into the details what happened in between. I can say that at some point the preliminary investigation was closed, and responsible high-ranked officers, they were not asked to come to be interrogated. We filed applications and to extend the investigation and to include additional evidence. It's worth noting that from the file, all conversations 2.5 hours before the shipwrecks are missing, that there was no record of communication with the Andriana vessel and with the Coast Guard boat, which is accused of the towing. Entire sections of critical conversations of the Joint Rescue Coordination Center, based in Piraeus and that was responsible for coordinating this rescue operation, are missing from the file. According to the existing evidence, it appears that from the control room of this Joint Rescue Coordination Center, the responsible officers coordinating the operation from neighboring phones without recording. And moreover, in these conversations, some of them are not officially recorded, but in others that are, officials actually are heard hours before the Pylos shipwreck, directing the refugees, putting in their mouth the words, so to say, directing the refugees on the fishing boat and passing ships to explicitly state that they do not wish to be rescued, but they wish to be transferred to Italy. All the above, given that every order given or omitted by the Joint Search and Rescue Coordination Center is crucial to forming a complete and clear picture of the circumstances of the shipwreck that occurred in calm waters and good weather. So there were significant developments during the last 6 months, and we had the Greek ombudsperson, they issued the extensive report that found clear indications of serious failings by high-ranking Hellenic Coast Guard officers. And this led to, in the end, after this report and its key findings, it led actually in the end to the, and on the 25th of May, to criminal charges against 17 members of the Coast Guard, and referred the case to an investigative judge. These Coast Guard officers now face felony charges of causing the Pylos shipwreck, failing to provide assistance, dangerous interference of maritime transport, and exposing others to danger. The 17 men accused include the commander and crew of Hellenic Coast Guard vessel, in addition to officers who were present in the Central Command Center, as I mentioned before. The investigative judge is now responsible for continued investigation, and a decision will later be made on whether to refer the case to trial.
Natasha, yes,
Yes.
I'm afraid we've run out of time. I think we're going to have to leave. Thank you so much for your excellent presentation on the criminalization of migration at Europe's sea borders, the horrific conditions that people on the move are facing, the details about the Pylos shipwreck, and litigation in domestic courts and the European Court of Human Rights.
Thank
We have
you.
time. I just want to make one statement that you, Natasha, you talked about the Greek authorities labeling migration as an invasion. That's the same word that Donald Trump uses in his executive orders to justify his illegal and inhumane attacks on migrants. We have 3 minutes left. Nicole, Camilo, do you want to each make a 1-minute statement, and then we have to call it a day?
I would just emphasize all of the commonalities that emerge from the presentations, and that we're talking about global patterns and practices, and that we have to always understand that the policies that are being applied, whether in the US or the EU, respond to global frameworks, and that they have to be responded to globally, and that the People's Academy plays a crucial role, I think, in bringing us together. And the organizations that feed into this, like IADL, the NLG and its equivalents in other countries and regions, and the NGOs like the Lesbos Center, like Haitian Bridge Alliance and other organizations, the Tribunal, et cetera, we have to act together. So I just think this is also a call not just to reflection, but to action on a global scale.
Thank you. Nicole, you want to say something?
And once again, Camilo, our thoughts are kind of converging. I think, Natasha, just congratulations on all of this work, and for tirelessly, co-founding this organization and litigating skillfully, like a surgeon, and trying to move the law. And I think this is a really exciting time. Exciting, it's an awful, awful time, and it's an exciting time to be a lawyer. And so for those of you that are lawyers or aspiring lawyers, thank you for your work. And sort of, as you said, Camilo, we all have a part that we can play in this, and we all must use whatever we have available, whether we're corporate lawyers, but this is our interest, whether we're, whatever it is. Please, plug in however you can. There's a Haitian proverb that says, main en pile, chai pa loup, which is many hands lighten the load. And we really need everybody to get involved. And thank you so much, Marjorie, for the People's Academy for hosting this and bringing us together. We could see, a lot of the similar themes and a lot of where we need to move together in order to try and provide a resistance that ultimately will prevail.
Well, thank you to our superb faculty, our administrator, our interpreters, and the task force of the People's Academy, and to all of you for attending this seminar. The next program of the People's Academy of International Law will be a seminar on the Korean War, unresolved ongoing conflicts, and U.S. involvement. It will take place on Thursday evening, September 11th, which is September 12th in Korea. And the faculty will include Peter Kuznick, Lee Si-woo, Lee Jong-hee, and Lee Kyung-ju. Thank you again. See you there.
Thank you.
Thank you so much.
Thank you, Natasha, Nicole, Marjorie. Thank you, Erin,
Thank you.
everyone.